Thank you very much. Good morning to all of you. I hope you can see me behind this podium. This is as tall as I get, so I'll try to make this clear for you. Alrighty. So the focus of my presentation is a little bit of a takeoff of what Ms. Shoup did, and Ms. Shoup's was probably far more entertaining than what I'm going to talk to you about today, but I hope that the things I can discuss with you will be relatable to what you guys do in your everyday business. So real quick, and really the last two slides that I'm going to focus on sum up everything, but I'll go through these ones quickly as well. So really a big issue right now is are cyber attacks covered under your normal CGL policy? Now, I'm sure you're all aware, obviously, coverage A of the policy is bodily injury, property damage. Coverage B, personal injury, and advertising injury. As far as property damage, this is currently the most widely used method of insurance to try to attempt to get coverage for a cyber attack. And the reality is, is computer software, is computer data, personal information online, does that constitute property damage? Does that constitute tangible property? And courts are split on this issue. Most policies, the typical ISL policy defines property damage as a physical injury to tangible property, including all resulting loss of the use of that property. Now that's an important phrase, especially with cyber attacks, that resulting loss of the use of that property. As Ms. Shoup just discussed, if an attack occurs and cyber data is frozen or anything like that, there's going to be an extremely significant resulting loss of the data. So that's a huge issue with whether or not a cyber attack is going to be covered under property damage. And this has become an increasingly litigious issue is that when a cyber attack occurs, the amount of declaratory judgment actions that are being filed either by an insurance company or by an insured against their insurer as to whether or not coverage should be provided as to any cyber litigation that follows. Here, this is a recent one, 2010, and this was an issue about an insured had a website, and visitors to the website were receiving ransomware that they were getting through the insured's website. As you can imagine, the insured was sued by more than one party as a result of the ransomware. And so the insurers, the issue was there going to be coverage from the insurance company to the insured for this issue? Ultimately, the court said yes, that constituted property damage under coverage A of their policy, and that the loss of use of tangible property that was not physically injured. So really, it's not too hard to understand, but it is a little bit of a deviation from what you consider property damage. But all in the same, it's property, it's intellectual property, and it's damaged. Going on to coverage B real quickly, and this really goes to the personal and advertising injury. And as you guys have heard, with the breaches, the big thing that gets stolen is personally identifiable information. So if you're insured is breached by a third party, and as a result of that breach, they steal data that your insured was responsible for holding. And you could think about that, and a law firm, the amount of data we store, use an insurance company, the amount of data you store on third parties. So if that occurs and a lawsuit arises, is there coverage going to be provided? And a lot of times it's split right now, but it's growing towards coverage, and the reason is that it makes sense that is a personal or advertising injury, that the publication of that data of personally identifiable information would fall underneath this category. This is a split here between Oregon and New York on this issue, but like I said, the growing trend is towards coverage under coverage B on this matter. Now, as far as specialized cyber policies, I don't know how many of you are writing them right now. It's sort of an emerging field, more and more are, and really it's an interesting thing, and the reason they're becoming more popular and the reason why cyber claims under CGL policies are becoming more contested is if they could contest it under CGL and the court rules no coverage, it makes it easier for an insurance company to try to sell cyber-specific coverage. So there is a little bit of a marketing advantage there. But the issue here really, and this is pretty simple, I mean, it's really not unique to cybersecurity, it's whether or not there was willful conduct or negligence. As any policy, not even related to cyber claims, if it's willful conduct, there's not going to be coverage, and much the same here. So this is really what I want to focus on. Just briefly, the checklist for handling claims. And the number one thing that I stress during these presentations is proactive planning. For those of you that either have never handled a cyber claim, or maybe you've handled a claim that might have a small cyber component, but it's certainly not the majority, it is imperative that you, as an adjuster, as an insurance company, take the time to sit down now and understand whether or not your CGL policies are going to cover cyber claims. What type of claims are going to be covered? What type of damage cap will there be? And the reason it's imperative to discuss this now, prior to a claim coming in, is because you won't have time when a claim comes in. It's an incredible amount of wasted time for a claim to come in, and for you then to sit and say, well, I got to talk to my boss, he's got to talk to his boss. Do we cover this under this provision? It needs to be decided ahead of time. So that's a huge issue for coverage, is the proactive planning. Monitor your insured's data security policies and make sure your insured is monitoring their policies. I know that a big issue a lot of times with plans that are starting to be cyber specific is that the insured essentially has to meet a threshold of protection before they can even get the coverage. And even if you're not writing cyber specific coverage, the same sort of mandate should be in place, because I'm sure you can understand with possibly your own data or with multiple of your insureds, their data security policies are probably non-existent in a large sense. So it's imperative to discuss that with your insureds and to make sure everyone is on the same page. As far as when a claim comes in, who breached? Was it a third party that came in and breached your insured, or was it an employee of your insured? And also, one of the things that we like to talk about too is, Ms. Shoup was talking about some really high-level attacks from terrorists, things like that. It can be just as simple as an employee leaving a cell phone in a bathroom, forgetting an iPad at the airport, and that can lead to a huge cyber breach. So it doesn't have to be some necessarily malicious or terrorist threat. Everyday things can result in cyber breaches. Notification. This is big. Probably in every state you're writing. I think it's 47 to 50 states now have notification laws, including Pennsylvania. And the laws are really, they're not too complicated. It essentially comes down to as soon as possible. You need to alert the authorities. You need to alert major stakeholders, whether that be your own employee, the employees of the insured, the public, shareholders if it's a public corporation, things like that. Expert consultation. Have an expert ready, have a list of experts ready now. Again, this is the same kind of thing, like I said, as far as determining coverage. These are incredibly time-sensitive matters. You need to be able to, stop the bleeding and stop it quick, and that's where an expert can be incredibly crucial. So it's imperative now to have a list of experts prepared, and if that's something you all are interested in, I can certainly help you put something together like that. But it's crucial to have that list now so that you know who to call immediately when an issue comes in. Playing right off expert consultation as stopgap measures in mitigation of damages. What can be done? I know recently I got a letter from the first law firm I worked at that my data had been breached. And now I left that firm over a year and a half ago, and I just now found that out. And as part of their mitigation of damages, or their stopgap measure, was they provided free identity monitoring for, I believe, a year or maybe 2 years that you have to log in and fill out. And so that's crucial for them to say, well, look, we were active. We tried to do something right away. Your data was breached. It may or may not be compromised, but the access was there. So here's how you can try to protect yourself. So that's a huge issue as well. Just like anything else, intermediate and long-term effects, what are they going to be? That plays right off the stopgap measure as well. Additionally, with the intermediate and long-term effects, depending on who you're insured is, if they're in the retail industry, obviously you can understand that consumer confidence could be shaken with a cyber attack. So it's imperative to address that, whether that be through public relations or in-house. Implementation of future security measures. And the final thing I put there on is settlement. I know with your typical slip and fall or car accident, usually pretty quickly we want to talk settlement. How can we get this claim in and out and off the books as soon as possible? Unfortunately, with these cyber claims, that's not really as easy. There's a lot, as you can see, that's why it's last on this list. There's a lot of issues that need to be addressed prior to doing that, because really the biggest reason for that is you don't know the impact of the attack until later on down the road. I mean, data can be stolen in 2013, but there could be no use of that stolen data until 2016. So it's difficult to evaluate and close a file quickly when it comes to this kind of stuff. Finally, tips based on case law. Usually in these presentations I go through several cases. Today we don't have time for that. But the simple things are, know the statutory law in each state which your insured operates. And that really goes to the notification laws that I was discussing earlier. It's imperative that your insured is on top of that and notifies all stakeholders immediately. Monitor the case law. Again, that's something at TT&H we do frequently for all the states in which we practice. And case law it's changing. It's evolving pretty quickly. Courts are a little hesitant to make sweeping rulings, though, and a lot of times they're deferring to the legislature, which is understandable. As I talked about earlier, advise your insured of the importance of adopting a system. That's both as far as external threats and internal threats. And when I say internal threats, I don't necessarily mean malicious. Like we said, the inadvertent loss of a phone, things like that, that's crucial. And your insured should have a system in place where they can remotely wipe a phone. That's huge. If they allow their employees access to their network, they should have also the same type of technology where they can wipe it clean. Establish a system for evaluating data breach claims against your insured. That's the proactive planning I was talking about. Look at your CGL policies. What's going to be covered? How's it going to be covered? Is it capped to a certain degree? That's crucial to understand now. And finally, look internally. Obviously, that your concern most of the time is dealing with your insureds. However, you as an you insurers, you adjusters, you possess a mass amount of documentation on a sweeping array of different people as far as medical records, employment records. So it's crucial to see how is your system protected, because really you are vulnerable to attack as well. That's all I have today. If you have any other further questions for me, I'll be here the rest of the day. I'm happy to answer them for you. Thank you very much for your attention.